we are very happy today to host this opportunity to talk through and to celebrate the Seventh Circuit Court decision on same-sex marriage. And this really is certainly not the end of the line, but it is an important milestone in our long journey to have national recognition and approval for same-sex marriage. And the ACLU has been really our champion on same-sex marriage now for a very long time. And to talk about the decision today, I'd like to introduce Chris Amity, who's the Executive Director of the ACLU of Wisconsin.
Members recognize that it's our lawyers and above all it's our wonderful clients who are behind this. The ACLU is very proud to be part of this movement and do our bit. And we are certainly in line to get to the U.S. Supreme Court should they decide to take our case. There are many others out there, and when we have questions, Larry and I will try to answer questions about what's going to happen next. But to give you a little flavor of the decision, here's the legal director of the ACLU of Wisconsin, Larry Dupuy.
One step left. I just feel so honored to be representing the couples here and the other couples in the case. This is about their families, their relationships, and their relationship to the government. And the government, Judge Posner said today, has no legitimate basis for treating them less committed, as less loving than their heterosexual counterparts. Judge Posner is known to be prolific and a quick writer. Some people say, I read that he writes the way other people breathe. But a week out. And this was not just, I mean, obviously they had been thinking about this. They got our briefs in plenty of time. They probably started thinking about writing this decision. And obviously, as with Judge Crabb, when an issue is this prominent and this much about what's right and what's wrong, it's not like they necessarily need the lawyer's briefs to sort of bring some of that home. But he obviously, all of the things that Judge Posner was concerned about during the oral argument come out in this opinion. He starts out right away with, if the state's interest is protecting children, how can they deny to the children of same-sex couples the same rights that they give to different sex couples and their children? He tells the same story that he told. I mean, here's Judge Posner, Mr. Cost-benefit analysis, starting out the oral argument by asking a question in the form of a story about the children of same-sex couples going home to the two moms and saying, the other kids, they have a mom and a dad. What about me? And if there's marriage equality, those parents can say, your parents are married too. Your relationship to us is just as recognized as the moms and dads' relationships with their kids at school. But if you have the regime that you have in Wisconsin and Indiana, that kid goes home, and what does that kid hear? Sorry, we can't guarantee you the same kinds of things that other parents can guarantee their kids. It's that second-class marriage, second-class citizenship, and the judge nailed it. It's a beautiful decision. I just barely finished it. But it's really a very strong decision. Another voice in the judicial chorus that I think is going to ultimately end, I hope, with the United States Supreme Court joining the chorus and leading us to that final step where we've got marriage equality all across the country.
Sure. Michelle Johnson, AP. Do you think there's any chance the Supreme Court would not take the appeal because they don't have to?
Yeah, there's a chance. The Supreme Court, in theory, could, especially if there's no circuit split, ultimately, where there's no difference in how the circuit courts of appeals are deciding this, they could just say, well, we don't really need to step in. But I think that's highly unlikely for a lot of reasons. This is the kind of sort of issue where the legitimacy of the Supreme Court is important to sort of validate this and have it be recognized broadly across the country. So I think they're likely to step in. Whether it's this case or another case is a lot harder question to answer. They could wait until they get a split. There's not one yet. It's 3 courts of appeals that have upheld the right to marry. And until there is a split, I think they might just continue to sort of wait, see how long it might be before there's a split. Or if there's no split, I still think they'll ultimately take a case. And they look at a lot of different things, and it's really hard to know what they'll be looking for. I think this case has been very well litigated. I think that the opinions of Judge Crabb and Judge Posner are great opinions. Other cases have been well litigated too. I think we've got a great group of plaintiffs and stories to tell, but all of these stories are effective because they're about real people in law.
Since the ACLU filed this case in February, one of our main reasons for doing so was to give a voice to couples or would-be couples in Wisconsin in this nationwide debate that was happening. We didn't know when we started if it would get to the U.S. Supreme Court, but I do know now that with these 2 great decisions of the Seventh Circuit and the Fifth Circuit decision, that we've accomplished our goal of giving Wisconsinites and their friends and allies a voice in this national debate. Georgia?
So after the Crabb decision, people were not sure whether to marry or not. Where does that stand now in terms of should couples go ahead and marry, or should they wait till the appeal process? Or do you have a comment?
Well, I can answer the question by saying what has happened in other cases. The Fourth Circuit, what happens after a Court of Appeals issues a decision, they issue a decision and a judgment. But it doesn't sort of go into effect until the mandate is issued to the district court. And the mandate usually issues 21 days after the judgment. And that basically is time to give the loser a chance to ask for both a stay from the Court of Appeals to stay their mandate, and to petition for rehearing en banc, which is when you ask the full court, all the judges, to take the case.
My understanding from media reports that the clerk in Dane County is not going to start issuing marriage licenses again. I don't know what's happening in Milwaukee County or with the courthouse. The ACLU, of course, believes that marriage licenses that were issued between June 6th and June 13th on the basis of Judge Crabb's order are valid, and that those marriages are valid. And it may be that with the rapidity of the appeal process that those people too are going to have their marriages recognized earlier than they would have otherwise.
Judge Posner did sort of 2 things, and sort of a belt and suspenders approach. He said, as he kept trying to get the state during oral argument to come up with a rational basis for their law, and they couldn't, he basically found that there's no justification, no legitimate justification that holds up to any level of scrutiny for banning same-sex couples from marriage. So what he's saying is, even at the lowest level of constitutional review, in legal terms, this law is no good. The ban on same-sex marriage is no good. On the other hand, he does say that this is a law that has its origins in a history of discrimination, and therefore the classification is suspect. So he does sort of a jig. He does both. He says, on the one hand, I think this is a case of heightened scrutiny. At oral argument, he described the history of discrimination against gay and lesbian people as savage. And, you know, so he kind of tipped his hand about what he felt about that. But he also took kind of an interesting legal approach to the whole thing. He sort of dismisses the complexity of various standards review and suspect classifications and talks about it just in a more common sense way. And I think what he's saying is, yeah, almost any discriminatory law against LGBT people should be subjected to this sort of level of review, whatever that level is. And I think what he's basically saying is, yeah, we've reached the point where we realized that was all